Welcome, students. We are going to look at civil rights. We previously looked at civil liberties. Now this notes will be on civil rights. It's very common to confuse the two with each other, but as we looked in civil liberties, a civil liberty is protection against the government, that the government cannot take away your freedoms. A civil right is protection of your freedom from another individual, that individuals in society cannot take away your rights. And so you have one where it's protection against the government, and the other one protection against individuals. Let's look at civil rights. Government may not unreasonably discriminate. That is the key right there, unreasonably discriminate. And obviously, with unreasonably, you do have some nuance, some gray area there. There's two standards with this. There's the rational basis test. Does the distinction achieve a reasonable government purpose? Example, drinking age. The age being 21 could be seen as violating a 18-year-old's civil rights, that they have the civil right to drink at 18 years of age, but the federal government has said that there is a reasonable government purpose to this, that individuals are not able to handle alcohol until they're age 21. Another example would be the mask wearing during this coronavirus, is that the government can restrict your civil rights if there is a distinct government purpose. They can't just arbitrarily say, oh, you can't have a church or freedom of worship, but if it's for a government purpose, they can. Strict scrutiny requires a higher standard and must show a compelling state interest. And the example of the coronavirus is a good example here. Required if distinguishing by race, sex, religion, etc. Example would be affirmative action. So the strict scrutiny is that the government can favor one group over another, in a sense, if there's a state interest there. For example, African Americans were disenfranchised for so long that affirmative action has been seen as constitutional by our Supreme Court, in that it is trying to right the wrongs of the past. And so, to what degree is really the question. Race issues, segregation. This is, the courts have shown this to be the most scrutiny. And this is the issue, race, and it's because of our historic battle over race. Brown versus Board of Education overturned Plessy versus Ferguson, the separate but equal doctrine. Remember that Plessy versus Ferguson ruling said that if there's separate facilities for whites and colored, aka black, then they must be equal. And it sounded like a good ruling. However, Brown versus Board of Education would say that the separate is inherently unequal, that you can pretend to have the same equality, but in actuality it is inherently unequal. And so this would integrate public schools based on the Civil Rights Initiative. But it took a long time for public schools to actually be integrated. Some it took around 20 years for that to actually happen, because this was 1954, and some wouldn't desegregate until the 1970s. Affirmative action is the policy that requires most employers, colleges, take positive steps to remedy the effects of past discrimination. So colleges, up until the 1960s, had policies where only whites could attend colleges. For example, Syracuse in New York. It wasn't until 1960 that an African American was able to attend that university and would end up winning the Heisman Trophy, first African American to do so in 1960. So affirmative action is to right that wrong. Precedents. Regents of UC versus Bake, no strict numerical quotas. So you're not allowed to give quotas, though that seems to still happen. Gratz versus Bollinger, race may only be a plus factor. So race cannot be a negative factor, but only a plus factor. For example, technically universities are not allowed to discriminate against Asian students from attending. For example, Stanford University is not allowed to have a quota against Asians, but they can have a quota in favor of to promote other ethnicities, minorities from attending. 2014, states may now vote to strike down affirmative action. So since 2014, states do have the right to not endorse affirmative action, to strike it down as they see fit. That is a state privilege over the federal government. What about women's rights? Women's rights is also a civil rights issue. The court has ruled reasonably distinctions okay. For example, the draft. So if there's a reasonable distinction, for example, a daycare can be just for females versus males, or the draft only applies to males and not females as well. Expansion of the rights over the years. The 19th Amendment was the first big landmark movement. Right to vote, 1920. 1960s and 70s, we have some examples of the Equal Pay Act. You also have the Title IX, which was in education, if you remember, that you cannot provide male sports or male activities more funds than female activities. Abortion, this has become an issue. Griswold versus Connecticut was the first to use right to privacy argument in the fight to promote abortion. Roe versus Wade would also use the 14th Amendment, right to privacy, in their ruling. Planned Parenthood versus Casey would also be a landmark ruling for abortion because the abortion argument has focused on the woman's body argument, the female body argument, versus the right of the life of the child. So that's where it's become a women's rights issue. However, the question is, what if the baby inside the womb is female? Does that baby, does she also have rights? That's kind of that catch-22. Homosexual rights have become the big issue recently. 1996, the Defense of Marriage Act, known as DOMA. National government will not recognize same-sex marriage. That was in 1996. President Bill Clinton signed that act. Remember that he was a moderate president, even though he was Democrat. Lawrence versus Texas, 2003. Government may not ban sexual relations between same-sex partners. 2003, Massachusetts, first state to legalize gay marriage. 2015, same-sex marriage was legalized everywhere. That was a landmark ruling. And then just recently, 2020, employers may not restrict employment based on sex, which is now been defined as gender, which is LGBTQ+. The initial ban or the initial ruling on equal employment was based on male and female, that there would be equal employment, that you couldn't base it on employment on a male or female unless there's a reasonable distinction. But that has also been now considered not just male and female, but also to transgender and plus. And so that was a big court case ruling. Thank you for taking these notes.